Good afternoon, everyone. Welcome to the first installment of Homeline's webinar series for 2023. We are going to be doing an overview of the developments in landlord-tenant case law in 2022. So thank you for joining us. We're going to just get started here in just a minute because we've got quite a bit to go over today. But I want to give folks just a chance, a couple 30 seconds or so to actually join in. But again, thank you very much. We are going to be joined by Dan Suter, who thank you for moving that back to the main one. I'll get into it in a second. So, all right, we seem to be slowing down on the joinings, so that's perfect. All right. All right, thanks everyone for joining us today. We are at 1:34, so we're going to get started. We've got quite a bit to go over. This is the first webinar for our webinar series in 2023. We're going to be going over the developments in landlord-tenant case law from the last year. We are joined today by our managing attorney, Mike Farah, and by tenant advocate, Daniel Suter. Daniel's going to be the one kind of running the show today for all of the cases. He's done a lot of review and work on making sure that we've got a good understanding about what has happened in the last year when it comes to landlord-tenant law in the courts. So without further ado, Dan, can you scooch forward a slide? I'm going to get through the intro stuff real quick. So Homeline, in case you didn't know, is a statewide nonprofit. We serve all of Minnesota. We help tenants across the state with legal, educational, and advocacy services. We've been around since 1992, and I need to update that number because we're actually more at about 294,000 instead of 260. So quite a few calls in the last few years. We do offer our programs in 4 languages, Mali, Hmong, Spanish, and English. So that is one of our through our main hotline, which is how we mainly interact with tenants. Next slide, please. These are the numbers for our various hotlines. And then we do also offer email services if folks prefer email in this wide world of ours. Email sometimes is easier. All right, I think that is it for my song and dance. If you have questions, we encourage questions. Any questions regarding landlord-tenant law, specifically about these cases, would be excellent. Drop them into the Q&A. That's going to be one of the functions at the bottom of your Zoom screen. The chat is, I'm going to be populating things in the chat, links and such that will be useful for folks to reference, but the Q&A function is the way to ask questions, and we really do encourage that. Again, test Dan. He's been doing nothing but this for like 2 months, so I'd say ask him some of the hard questions. And then we will have time for questions at the end as well. So without further ado, please take it away, Dan.
Hi there. Just a little personal introduction. I'm Dan Suter. I'm a tenant advocate here with Homeline. I've been with Homeline since September 2021. I am a recent graduate of the University of Minnesota Law School. A week from now, I'll actually be logging in to get barred as an attorney, but for now, I'm just a lay advocate. I've put up our topics for discussion. It's pretty ambitious, but there's, at least 8 decisions that I want to go over. Some Presidential Court of Appeals opinions, some Supreme Court decisions that are relevant to landlord-tenant law, and a couple of non-presidential opinions that I think are pretty instructive, and they can give us some good practice pointers. There's also some cases to look out for if we have the time, some interesting issues up on the horizon. So I want to give a little bit of a general primer here. Why are we talking about case law? Well, there are 2 main sources of law in the American legal system. The first is statutes, written laws. You can go look them up in the books or look them up on the internet, but those are the actual laws passed legislatively. And then there's case law or common law. They're largely interchangeable. This is the law that is propagated by judges. And landlord-tenant law is an interesting creature. The modern version has really been iterated since the 1950s and 60s, but it's based on a combination of contract law and property law. And those issues, yes, just so you know, Tess, the link I posted with the Dropbox has everything you need. It has a bunch of documents and it has the slides itself. So the, landlord tenant law, a combination of contract law and property law, which date back hundreds of years. And a lot of those concepts were really originated or iterated on by courts. So you have lots of concepts that are really not even contained in our written statutes. And in addition, case law also explains to us how to apply the modern statutes we have, because a modern statute couldn't be written to cover every single possible iteration. A single law would be hundreds and hundreds and hundreds of pages long. So we have courts that explain to us how to use them. So just want to say, these are the latest developments in how to practice housing law in Minnesota. Let me just get to the next thing. I want to explain a little bit about the hierarchy of courts. If you're not deeply involved in the Minnesota legal system, when you file a case, you file it in a trial court. We're just going to call that district court. You can also file a small claims court case, but you file it in a trial court. You have your case, that's your law and order stuff. And if one side doesn't like the final decision, you have the right to appeal it to the Court of Appeals. Our Court of Appeals hears essentially every single case filed from a final judgment. You have the right to a single appeal here in Minnesota. If one side doesn't like what's going on at the Court of Appeals, they can appeal to the Minnesota Supreme Court. From here on out, if I say Supreme Court, just assume I mean Minnesota Supreme Court. I don't think there will be a discussion of the United States Supreme Court today. So the Supreme Court has the discretion to take whatever cases it wants that apply. You have to ask the Minnesota Supreme Court permission for them to hear your case, and they can say no. And so when the Minnesota Supreme Court decides a case, it is binding on all courts below it. If the Minnesota Supreme Court says something, it is law, and the Court of Appeals has to follow it, and all district courts have to follow it. When the Court of Appeals makes a precedential decision, it does not bind the Supreme Court. The Supreme Court does not have to follow the Court of Appeals, but the district courts do have to follow the Court of Appeals. Now, you may have noticed that I pointed out precedential. The Court of Appeals has the option to make a case non-precedential. A precedential case just means that the decision in the case binds all trial courts in the state as a matter of law. A non-precedential case only binds the single case it's deciding. It can be instructive or persuasive, but you can't cite a non-precedential case as binding law. And I want to just do a quick once-over here on citations. You're going to see a bunch of these. A citation is a lawyer's way of telling other lawyers exactly what case we're talking about. So you have the party names that are abbreviated by a uniform or semi-uniform abbreviation schedule and a citation manual called the Blue Book. That's just a way of shortening the names of the people involved. The reporters are big legal books that are published by the Thomson West Corporation that contain all the major case decisions in an area. The first number is the volume number. The second number at the end is the page number on which the case begins. So in this case, this is the first case we're going to be discussing, New York properties, NY properties versus Schutte. You would look up the 977th volume of the Northwest Reporter, second edition, and go to page 862. The second part is just telling you what court it is. Again, there's a set of abbreviations. For our purposes today, if you see this one, this means Minnesota Court of Appeals. And if you see just MIN, M-I-N-N, that means Minnesota Supreme Court. We have the year the case was decided. And while this is not a part of the formal citation, I did want to throw in the A number at the end. The A number this is the format that Minnesota courts use to file their appellate cases. So I put the A number in for all these cases because that's going to be the way you find these cases for free. Reporters are a paid service. You can generally only access them through paid legal research databases, but if you have the A number, you can find these cases on the state law library's website or in the state's appellate court management system. And I've put it again in here. I put it in the chat box, but there is a link to the Dropbox folder with a lot of the relevant documents that I'm talking about, organized just so that if you don't have to track down a lot of the documents. I've also put these slides in that folder. So thanks for bearing with me there. I did just want to do some baseline setting.
Hey, Dan, can you go back one slide for a second?
Yeah.
Thank you. I just had a couple points here. First of all, the site that you described there, the easiest way I've always explained it to people that aren't attorneys is these are sort of coordinates. You said it was the name of the case, which is true, but it's really how judges and lawyers find these things. And so frequently, if we're sending a tenant into small claims court with a security deposit dispute, we'll say, here's the statute number you need, so you can tell the judge how to find it. And that's really what you've given people, is the coordinates that lawyers and judges use to find a case. But the other thing was a question I had. So you have presidential versus non-presidential opinions. What's the difference between that and published versus unpublished opinions?
That's a good point. There is no difference. A presidential, the court changed its terminology recently, I think within the last few years. The Minnesota appellate courts used to use the phrase published versus non-published, but that was kind of weird because a lot of non-published cases were published. You could find them, you could look them up. So really what the effect of those words were is you could cite a published case as precedential in all cases, and non-published cases were non-precedential, except as to the case they decided. So you may see references in older resources to published and unpublished cases. You can sub in published for precedential and unpublished for non-precedential.
Well, I'm glad for one they changed it. You're right. You can find unpublished opinions that have been published. To me, it was the most misleading thing I've ever encountered in my life since imaginary numbers were introduced to me at a young age. And I thought, well, how can I ever be wrong if it's an imaginary number? It's in my imagination. So anyhow, thank you for that quick explanation.
Thank you, Mike. And we're going to move on to the first batch of really meaty cases. The first two cases, we're going to allot about 15 minutes each for them. In my opinion, these are two of the weightier decisions we have. And then we'll move into some cases that I don't think will take as long to discuss. So at the end of the discussion of each of these cases, we are going to pause to take questions specific to these cases. And you can save them for the end if you want to. But if you have questions about these cases, we will pause at the end of my little presentation so that we can dig into them. So we're going to start with NY Properties LLC versus Schutte. I did listen to the oral arguments again recently for this, and the advocate for the tenant in this case made it clear that it is pronounced Schutte. So I'm going to put up some information here. This is an appeal of an eviction judgment that was the tenant was evicted for non-payment of rent, for holding over, which is staying after a lease has ended, and for material breach of the lease, basically breaching the lease so bad that the court says you should be evicted. Those are the only three grounds to evict somebody in Minnesota. So really the tenant lost as much as they can lose. So what are our facts here? Well, the defendant showed up at the hearing and asserted defenses and said, I disagree with that. That's, invalid. Basically said, hey, I have defenses here. And they said that, hey, I'm trying to get this back rent paid, which is your right in Minnesota. If you are being evicted for non-payment, you have the right to pay what you owe plus your landlord's filing fees and have the cases dismissed. Well, the district court ordered eviction from the bench, said, I see enough here to evict you, and then issued a written judgment evicting on all three grounds. So you may say, how did we get here? Where's the error? Well, this hearing lasted 6 minutes, and the defendant threw out a lot of disputes of the facts and asserted defenses. This is the transcript from the case, and you can see that this entire hearing took about 6 minutes, according to the court reporter. You can see in the text here, Mr. Schutte is disputing facts, presenting defenses, and the court just says, well, I see enough here, and I'm going to evict you. And furthermore, there was no formal evidence in the record in this case. This tenant was evicted based on no evidence. The landlord did not testify. The attorney presented some things, but that's not testimony. They made a legal argument, but there was no evidence in the record. This is there were some documents attached to the complaint though. And this is very common. We see this happen all the time. For example, the landlord claimed that one of the material breaches was that the tenant wasn't maintaining the property. And as you can see, this is a dirty sink. And the landlord claimed that this was one of the reasons why the tenant should be evicted. I'm the parent of a 1-year-old, and I can tell you this is what my sink looks like on most days. And I'm very glad I don't have that landlord as my landlord. Next, I just want to point out, one of the reasons the landlord was trying to evict is because the tenant had called the police a bunch of times. Well, a tenant cannot be evicted for calling for emergency assistance. You can see it here in the eviction complaint that that said the tenant has had numerous contacts with law enforcement, and you can see that the law says you can't impose a tenant on that. So that's another defense right there that the court blew past. And finally, neither the landlord nor the tenant addressed holdover, staying after a lease was over at the hearing, and the judge ordered it anyway. In fact, this is probably completely legally invalid because the tenant still had time left on his lease. The landlord claimed to have terminated the lease before the lease was over and filed for holdover on those grounds. So what's our holding here? What did the court say? The Court of Appeals said that a district court cannot order an eviction at a first appearance if there are genuine disputes of material facts. To put another way, you need a factual basis to actually evict somebody. Put another way, the rules of evidence and civil procedure do in fact apply at eviction first appearances. You can attach documents to a complaint, but you have to formally offer them into evidence. And for any evidence that requires foundation, you have to lay evidence. Now, one might ask, what are we doing here? Isn't this already the law? Well, you would think, and this is where I get into my opinion on the case. The Court of Appeals did not have to make this opinion precedential. They just didn't. This is kind of a classic case where the Court of Appeals writes a quick and dirty decision that says, hey, here are the mistakes of law. You need to go back and have an actual eviction case. But the Court of Appeals chose to make this precedential. And in my opinion, this case is meant to be a corrective to some loosey-goosey eviction case procedure in courts that may not be as familiar with landlord-tenant law. To stereotype, I think I personally see this kind of behavior more in outstate counties, in counties that don't have as much rental housing outside the Twin Cities metro. And what Schuette does is it provides clear, concise, unambiguous precedent on what law applies in an eviction first appearance. It's really important for tenants. The tenant asserted defenses. The facts did not support an eviction in this case. Other than non-payment of rent, certainly the landlord could have pursued that, but there was no evidence in the record that the tenant even owed rent. There was no testimony, there was no, rent ledger, and the court ordered an eviction anyway. So I want to open the floor. So what's our practice pointer on this? Was this an outstate case? Yes, that was. This was in Stearns County, which is the county that contains St. Cloud. I find that St. Cloud courts usually do okay, in my experience. They do have a fair amount of rental housing in St. Cloud, so I think they see those cases enough. This is a particularly egregious case. And one of the things that's going to come up throughout this presentation is that weird facts make law. If the eviction, if the court had just set a trial and taken some evidence, taken some testimony, Mr. Schuette would have been evicted, probably no questions asked.
Dan, you mentioned a difference between outstate and, I guess, non-outstate or metro courts. So what are the key differences between those things? Who hears the cases in St. Paul or Minneapolis versus in Bemidji?
This is a very good question, Mike. In Hennepin and Ramsey County specifically, but we do see it in other counties in the 7-county metro, housing cases will often first be heard by a referee who is not a judge. They are a staff attorney essentially, or they're a contracted attorney for the courts who specialize in housing court cases. And why is that? It's because there's a lot of housing court cases. Ramsey County and Hennepin County have dedicated housing courts that are staffed entirely with referees. Other counties, they may not have formal housing courts, but we see them use referees from time to time. And referees, they hear these cases on the regular. They are very, very well versed in eviction law, in repair law, and other housing issues. Is there anything else I should touch on that, Mike?
No, I was just, we do have a question. Are there certain judges in Minnesota who are repeat offenders, opinion offenders for landlord-tenant cases, from Bree? I'm guessing that's kind of hard to answer, because what you just described is, it sounds like most judges outside of the metro sort of at best dabble in landlord-tenant law. And that's part of the reason why they might get things wrong, is because they just don't deal with this on a daily basis.
As somebody who's about to go into legal practice, I want to say I am not making that allegation against all outstate judges. I think most outstate judges are doing their best with this. They just are less familiar with it. It's a lot to study up on an issue you may not be familiar with. You know, district court clerks are very busy, and they're the ones who are really writing the bench memos and doing the research to say what will happen here. In my personal experience, I did not see, I haven't noticed repeat offenders. Maybe other people have. I personally haven't. I think depending on the case, I certainly see good decisions come from outstate judges, and I would not paint them all with the same brush. I think if you're less familiar with a case, you may be more likely to dispose of it improperly. The fact that this was disposed of in 6 minutes, I mean, I'm not gonna say much more, but this was certainly a case that needed more than 6 minutes. Lisa asks, what happened with this tenant? Well, as a postscript, the trial court stayed the writ of recovery, which is the order a court issues that says, hey, you can evict this person. But they said, if you want to appeal this, you have to pay a rent bond. That appeal actually went all the way to the Court of Appeals, the Supreme Court. Sadly, this tenant actually passed away suddenly over the summer. His Supreme Court case was dismissed because he passed away, and there was therefore nothing left to decide. You know, it was sad to hear. This case, though, is binding precedent. Case was decided right around the time that he passed away. So it was put on the rule books before Mr. Schutte passed. So
and Dan, I apologize. You mentioned 6 minutes twice now. So how long does an average eviction initial hearing take? Or
I think the average initial hearing in the ones I've observed, they may not even take 6 minutes. The thing here is that there were no facts. You know, to rule an eviction with no evidence in the record in 6 minutes when a tenant asserts defenses, that's really the issue here, is that there were disputed facts. You know, eviction, we don't really apply like formal civil procedure applies at eviction first appearances, but we don't really talk about it in those terms. But essentially what's happening is if you are being evicted at your first appearance, it's essentially summary judgment. And, you know, because it's, you know, that's essentially what's happening. And there has to be evidence in the record to ground that.
So, I mean, the giant majority of eviction cases, it's a non-payment of rent case.
Mm-hmm.
And so if the tenant shows up, which they frequently do not, the judge will ask, do you owe the money? Which is sort of a, hey, do you have any defenses question? But they're just trying to make it understandable, I think, for a pro se tenant, which is typically who appears. So what if the tenant just says no, or I says, I do owe the money? Is that enough evidence for the judge to say, well, you lose then?
I do owe the money. Yeah. Evictions in Minnesota are generally pretty easy. If a tenant owes the money, they're almost certainly going to be evicted. I could obviously point to edge cases, but yeah, if a tenant admits, that's testimony, that is evidence that the tenant owes the money. Absent anything else, if it's only an eviction for non-payment, yeah, they could absolutely be evicted for that.
Fair enough. Thanks.
All right. So I want to offer the people a chance to ask any questions you have left about Schutte. My number one takeaway from this would be tenants have a better lever to take cases to trial. They always had those rights, but the court has very much clarified for courts, hey, if there are disputes, if there are defenses, you have to allow a trial. Absent any other questions, I'm going to move on to Quinn versus LMC NE, Minneapolis Holdings. Just to put some information up there, this is an appeal of a lockout decision. A lockout is a procedure that a tenant can file, is a case a tenant can file when they are unlawfully excluded from their rental dwelling. That can be a literal exclusion, like it's called a lockout, because a lot of times landlords change the locks. It can also be constructive exclusion, where a landlord cut power to the unit, shut off utilities, took a door off the hinges, that sort of thing. That is also valid grounds for a lockout petition. What a lockout petition says is, I have the right to occupy this rental dwelling. My landlord is denying me that right unlawfully without going through the legal process. Please let me back in. So I do just want to say, I want to give a quick content warning for domestic and emotional abuse. So there's going to be an overview discussion of some of the facts in this case, which deal with domestic abuse. If you don't want to hear that, please come back in 15 minutes. I'd love to continue our discussion with you, but I can understand if those facts might be hard for people to hear. So with giving people a minute, I'm just going to move into the facts then. So the plaintiff in this case, the tenant, lived with their romantic partner in a nice building called the Nord House. Their romantic partner had a lease. The plaintiff was not on that lease. The plaintiff had an oral sublease with their romantic partner. The romantic partner's lease banned subleases, so this was an unlawful sublease. Many facts in this record suggest domestic abuse by the romantic partner against the plaintiff. Specifically, there are facts in the record that suggest that they eventually broke up, that the ex-partner used housing as a form of control over the plaintiff, refusing to put her on the lease, etc., was a way of abusing the plaintiff. At some point in the ex-partner terminated the lease without telling the plaintiff and moved out. The landlord's employees found the plaintiff in the unit and deactivated her key fob. Without that key fob, the plaintiff couldn't get in and out of her apartment, and so she filed a lockout petition. The referee and the district court both ruled for the plaintiff. One thing, this was a Hennepin County case, so there was a housing court. First heard by the referee. You have the right to appeal a referee's decision to the district court judge themselves, and they both ruled for the plaintiff. The district court did reverse a finding of bad faith with money damages, but essentially the same whole ruling. The ruling is the same. The tenant was unlawfully excluded from the apartment. Well, the landlord appealed, and their argument was, this person is not our tenant. They are a trespasser. Why are they a trespasser? They were never on a lease. They didn't have a lease. So the landlord's argument was, this is a trespasser. And the tenant's argument was, I'm a tenant. And so the legal issue was, who qualifies as an other regular occupant under the definition of residential tenant? So I'm going to put up the definition of residential tenant. You are a tenant in Minnesota if you are, one, a person who occupies a dwelling in a residential building under a lease or contract that, requires payment of money, blah, 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 comma, all other regular occupants of that dwelling unit, or three, and this concerns manufactured home parks. So really the question here is, under item 2 here, and I've added those numbers, is the plaintiff another regular occupant of the dwelling unit? Because she certainly doesn't have a lease. So is she another regular occupant? And what did the Court of Appeals say? It depends. Our favorite answer in the law. The Court of Appeals specifically said that it is a case-by-case, fact-specific analysis, that you have to consider a bunch of different factors. And the Court of Appeals helpfully provided us with some factors. It used as guidance this case, Asseltine versus Fay Hotel, which concerns a college teacher staying at a hotel in Virginia, Minnesota, from about 80 years ago. In that case, she, wanted to be found to essentially be a tenant of the hotel. The tenant, or she wanted to be found not to be a tenant because of innkeeper law. I'm not going to get into that. That's a little too obscure. I wanted to put up both sets of factors. So on the left are the factors from the 1946 case, and on the right are the factors the Court of Appeals said you should consider in deciding whether somebody is an other regular occupant. These are not the only factors you can consider. This is an inclusive list. So I thought we should go over it in this case, weigh the factors in this case. I thought it might be a good object lesson. So here are our factors: the duration, continuity, and nature of the residence occupancy, the existence or the terms of a lease or other agreements related to the occupancy, and whether the landlord knew of or reasonably should have known of that person's occupancy. So factors weighing in favor of the plaintiff. She lived there for around 3 years, from May 2018 to this was filed in roughly, I believe, April 2021. So she lived there for almost 3 years. She had no other permanent resident. She really just conducted herself like any other tenant. She lived there. She went in and out of the building. She got her mail. She talked to the building staff. She was a web designer and had, I believe, and had business meetings in the lobby. It was a beautiful building, nice lobby where you can talk to people. By all accounts, other than the fact that she didn't have a lease, she was like any person living at that property. But here are the factors weighing against her. Well, she never had a written lease. She never formally requested one, nor was she approved for a lease by the landlord. She paid rent to her ex-partner, her co-tenant, and not the defendant, not the landlord. Now, the defendant claimed to have no knowledge of the plaintiff, and I think this is a ridiculous claim. This is a corporation. A corporation has no knowledge. A corporation is nothing but a bunch of papers in a drawer at the Secretary of State's office. The knowledge of a corporation is the knowledge of its employees and agents, people who can act on behalf of the corporation. It's very clear that the building staff knew that some of the building staff, at least, knew that the plaintiff had been there for years. She was very well known to the building staff. So they didn't really argue that point. I thought that was a ridiculous point, but it's just my bone to pick. So, I want to pause for a second and say, how did we get here? What is going on with this? Why didn't they just evict her? Well, the eviction moratorium. This is really a holdover case from the eviction moratorium. In most cases, I don't know if the landlord in this case would have locked her out anyway, but they were certainly prevented from filing evictions during the eviction moratorium at that point. And in general, lockouts are generally come from a place of like frustration from a landlord. In my personal experience, my 1 year of housing law experience, I see them more with smaller landlords who are more personally involved with the goings on at their properties than with a large corporation. I hear a lot of threats of lockouts, but lockouts are in fact very rare. Thankfully, they're very rare. But there is a recent Cura study using some data from Homeline that actually suggests that post-pandemic, there are more extrajudicial tenant displacements. That's a hyperlink. If you click on that when you get the file, you can go read the Cura study. But it does suggest to me that there is increasing hostility from landlords towards their tenants and a willingness to take their law into their own hands. So what can we take from Quinn? What are our practice pointers? If you are a landlord or a landlord's attorney, do not lock anyone out. Just don't do it. It's very easy to evict somebody in Minnesota. Landlords' attorneys claim otherwise, but it's very easy. Just don't lock anyone out. Evict people. Don't lock them out. These are real people we're talking about. We're talking about putting somebody on the street because a landlord's feelings were hurt. But if you must use self-help, if you absolutely insist on locking somebody out, be very careful and conservative in how you differentiate between a tenant and a non-tenant. Is somebody truly a trespasser, or are they just annoying you? are you mad at somebody or are they breaking the law? There's a big difference there. And just be very, very, very conservative, because locking somebody out, which legally that's called ouster, is punishable as a criminal misdemeanor. And if the tenant suffers damages as a result, they can sue you for 3 times their damages. When people call me about lockouts, I always say, don't go stay at the Four Seasons, don't go stay at the Ritz. But if you do have to stay at a hotel and you're successful in suing your landlord, they're going to have to pay 3 times what you paid for replacement housing. Also important, if you are found to have locked somebody out in bad faith, you are liable to your tenant for their attorney's fees. And as we'll talk about later, that can add up quite a bit. Now, one thing I've heard from landlords' attorneys, both in the arguments at this case and otherwise, is that this case is going to give squatters so many rights, and that this is really going to make it hard to evict. Wrong. This case has been precedent for 9 months and the sky hasn't fallen. We haven't seen people walking into apartments and saying, I live here now, in en masse. This really, really, really covers edge cases. I will say most landlords do not lock people out. There are a lot of rental, lockouts are not one of our top issues at Homeline. It gets threatened a lot, but we really don't see a lot of actual lockouts. So these are very, very, very rare cases. And this has been precedent for almost a year at this point, and the sky hasn't fallen. So it's really covering edge cases. So why is it important? Well, lower income tenants are less likely to have a written lease. The landlord in this case argued that they had the right to lock out the tenant because she did not have a written lease. We just know for a fact, there's some great studies, especially out of Philadelphia, I think is the main study, a really recent one, that shows that lower income tenants are just less likely to have a written lease. If a landlord could lock anyone out who didn't have a written lease, we'd have a lot of bona fide tenants getting put out onto the street. And as I said, this is really protecting a small subset of tenants in edge cases from being forcibly displaced. And forcible displacement is bad. This is called self-help, where a landlord does not follow the legal process for evicting somebody and instead helps themselves. Self-help. Self-help is bad. We have 100 years of policy, both legal, both statutory, and in the courts that say we disfavor self-help because it leads to violence. And there are a lot of, not in Minnesota that I've seen, but there are a lot of cases in other places that show, disputes over landlord self-help can end in violence. I think there have been a couple shootings in Detroit over landlords coming to kick people out. So self-help is bad.
Dan, we got a couple
yeah.
thoughts that came in on this. The first one is from Lisa, which is kind of a factual point out that, hey, the tenant had a key fob. How do you get one of those if you aren't on the lease? Fair question.
I think it's a fair question. I don't think it's dispositive, but I think it's important. I will say a key fob, I can give anyone my key fob. I can give my friend my key fob. It doesn't make them a tenant.
Right, but you don't have 2 of them, right?
Yeah,
because I assume that the leaseholder had one. I think
no, they only had one. They only had one. The facts of the case, I believe.
Oh, so the landlord took away the key fob from both of them.
No, so there was only ever one key fob because there was only ever one person on the lease.
Yeah.
And so when the ex-romantic partner left the apartment, she left the key fob behind with the plaintiff.
I see.
In this case.
Okay.
So she did have a key fob. It is an important factor. I don't think it's dispositive, but my thing is she lived there for 3 years. People knew she was living there. Tess asked.
Yeah, I'll get to the next question. You can have a sip of water or something if you like.
Thank you.
was Quinn attempting to obtain her own lease after the ex-partner moved out?
Based on my review of the record, she did not apply until legal proceedings had started. Again, the facts of this case are a little complicated. She did not apply for a lease. She was not paying rent. Again, the facts are not totally on her side in this case. There is no doubt Ms. Quinn could have, and in fact was evicted. She was eventually evicted for non-payment of rent once the eviction moratorium was terminated, or sunset rather. She was evicted for non-payment of rent. The answer was the landlord always had the right, they were prevented from evicting her during the eviction moratorium. But the answer isn't you lock someone She did not attempt to obtain her own lease until the legal proceedings were begun, and she did not have the income at that time. So I don't think she qualified for the apartment. That's based on my review of the record.
Okay. And of course, we have Paul Bernberg writing in. Paul knows as much about landlord-tenant law as anybody else in Minnesota. His point is, I don't think Ms. Quinn provided an proved an oral sublease. I think she withdrew the claim before she got to the Court of Appeals. She did prove some permission from the leaseholder to reside in the apartment. In fact, the leaseholder allowed Quinn to be her roommate. And while you have been discussing this, I looked up trespasser in Minnesota, and I've looked at it before for other cases. It requires, based on my my cursory reading of it, that somebody takes possession or comes onto a land illegally, knowingly illegally to begin with, and retains possession. So you used the word trespasser earlier, which is kind of what Paul's getting to is, hey, wait a second, whatever we had here, was this actually a trespasser or not? And that seems like a hard argument for the landlord to make if they were an invited guest of the actual leaseholder, right?
Yes, I agree. I will say I don't have a high opinion of the landlord's argument in this case. I don't want to go any further with that. I think they had really bad case, and essentially this was all out of frustration that they couldn't just evict somebody. They absolutely had grounds to evict somebody.
During the moratorium, the eviction moratorium, that's what it was born from?
That's really, look,
okay.
Like I said earlier, weird facts make law.
Yeah.
We had a once in a generation eviction moratorium. I guess I don't want to not engage with your point there about the trespasser. I think it would have been almost impossible for her to be a criminal trespasser, but as we'll discuss later, courts can sometimes use criminal law language in a civil context and not apply criminal law. I think they probably would have taken guidance from that. But I don't think that, I just really don't think the landlord's case here was strong at all. So
we got another point here from Judith saying that we can get fobs where I live for persons not on the lease if they pass a background check and pay a fee. Yeah, I'm sure that people have the dog walker or somebody that's watching their kid after school. There'd be a lot of reasons why you could think somebody would want a fob even if they don't live there.
And that's why I think it's important that the Court of Appeals pointed out that these are inclusive factors. The court can take the court deciding a case based on Quinn can absolutely consider any facts presented to it. It may find them not relevant, or it may find that they support a tenancy or don't support a tenancy. They might look at the landlord's policy. The landlord could present their policy documents, any agreement you sign to get the fob that says this does not create a tenancy. I think that, again, that's why we have our it depends case by case basis. So are there any other questions on Quinn? Because
looks like no.
So this case, I'm going to just put it all up on screen. After some really weighty cases talking about really tough facts, I'm going to bore you to tears talking about bilateral bond requirements. I love appeal bonds. I hate them, but I love thinking about them. So I'm just going to put all the information up here. This is an appeal of an eviction judgment. The tenant was evicted for non-payment of rent and for holdover, for staying after their lease was over. The tenant appealed, and the court said, hey, you have to post a bond to appeal the non-payment issue. A bond is required where a tenant pays a lump sum of rent into court in order to appeal their case. And their argument is, well, if you're, a landlord has to be assured in some way that they're going to get paid for the rent they're missing if you appeal this, if you're going to stay in the property for even longer.
Dan, I'm sorry to cut you off. Is this backwards then, what you have written here on procedural posture? Because it says requiring a landlord to post bond?
No.
Okay. All right.
And this is where the bilateral bond requirement comes in, because there's some really messy procedural back and forth. But eventually the district court says, actually, this person does not have to leave the apartment. And in fact, landlord, if you want to evict them, you have to post a bond. And those bonds can be pretty large, because in a holdover case, I'm going to put the law up now. This second part, subdivision 7, covers the bond requirements in a holdover eviction. For non-payment or breach, the tenant can insist on being allowed to stay in the unit if they post the bond. But in an appeal of a holdover eviction, the tenant is roughly entitled to a stay of eviction. And that's just a policy choice based on how holdover evictions work. But it permits the landlord to get that eviction order if they give a bond condition to pay all costs and damages in the event the tenant wins, because it's saying, look, maybe you'll win, maybe you won't, but if you want permission to move the tenant out now, you have to put a bond into the court that promises to pay their damages if they win. And so why am I talking about bond requirements? Well, bonds are a huge obstacle for tenants to appeal their case. Remember earlier when I said that Schuette actually went up to the Supreme Court on a bond issue? Well, Homeline wrote an amicus brief in that, arguing that lump sum bonds are really bad for tenants. And what courts often do is say, hey, you have to pay, almost a year's worth of rent into court at the same time. And I don't know if you have 10 months rent in your bank account right now that you can spare, but if a landlord wants to file an eviction case against you and you want to appeal it eventually, you might have to put all that in trust with the court to vindicate your rights. Holdover cases are odd. Holdover cases are the only kind of eviction case where you have a defense of retaliation. Holdover cases are inherently fact-based because a landlord has to have terminated the lease. And the tenant can then argue legally that that termination or non-renewal was retaliation. And so, with those facts in play, our law says, look, the landlord can get that person out even if they appeal, but they have to give a bond. The landlord here did not want to give a bond. And what did the court say? Yeah, the court can make you post a bond. It doesn't have to. But it is within a court's discretion to require landlords to post a bond as well. And here's the key thing. Even if a tenant does not post their bond, if holdover has been pled and ordered, the court can say, hey, you still have to post your bond to get that on appeal. And so you might say, well, if there's reason to evict for that other reason, non-payment of rent, why does the landlord have to post the bond? And the answer is the court says so. Holdover evictions are treated differently. And that's put another way, if we see landlords plead lots of stuff. They like to throw all the spaghetti against the wall in an eviction case and see what sticks. Well, my practice pointer is if you're a landlord's attorney and you want to plead holdover, even when it doesn't apply, which a lot of them do, be careful because the court might require you to post a bond if your tenant appeals. Stick to actual legal grounds for eviction is my advice to landlords, attorneys, and landlords. So I want to offer to answer any questions about that very technical bond issue or any questions about Schuette or Quinn before I move into Minnesota Supreme Court opinions. With nothing else, moving on, I'm going to talk about more technical contractual matters. We're going to talk about exculpatory clauses. So again, I want to give a slight content warning. If a discussion of serious injury to a young child would be difficult for you to hear, come back in 8 to 10 minutes and we'll be done with this case. I completely understand. Having a kid has totally changed how I watch movies where there's a child in danger. So if you don't want to hear a discussion of an injury to a child, I'm going to give you a second to log off before I move into the facts of the case. Hearing nothing, this is one appeals decision in a long-running personal injury case. This was filed, 3.5 years ago at this point. And the facts actually started a dozen years before that. In 2007, a 7-year-old boy fell off the top of an inflatable play structure, one of those blow-up play sets, and hit his head directly onto a concrete floor. his mother had signed a waiver of liability that exculpated, or basically said that she could not sue the defendants, that the defendants were not liable to her or her child on any and all claims. And these generally are legal. We know this. We have all signed a lot of things that say, hey, you can't sue me. Once the plaintiff turned 18, he sued and he said, hey, I have serious and permanent injuries that arise from this injury. I have a traumatic brain injury. And so, this is not a landlord tenant case. This is a personal injury case, and you'll see where it comes in a minute. The defendant in this case said, hey, you said you cannot sue us at all, any and all claims. Well, the Minnesota Supreme Court said no. I got my order wrong. This is the actual exculpatory clause. I went into the record and found it. This is what the individual's mother signed. I have signed hundreds of these in my life for the various activities I've done. I'm sure we all have. It's worth thinking about what kind of effect a single signature can have on somebody's life. And so what did the Minnesota Supreme Court said? No. If you want to exculpate yourself for negligence, which is a form of personal injury lawsuit, that you have to specifically, expressly, or very, very, very clearly exculpate yourself from negligence. Put another way, negligence is not covered by an exculpatory clause that purports to exculpate for any and all claims. So, why am I talking about this? Well, in my experience, I have seen a lot of exculpatory clauses in leases. I have spoken to tenants about exculpatory clauses where they say, is this really saying I can't sue my landlord at all? And the answer generally is sometimes yes, sometimes no. I think in my experience, these are most commonly these clauses that say, hey, you cannot sue me for any form of injury, blah, 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 are most common in low cost, like your legal Zooms and whatnot, like your low cost internet legal resources where you can pay to get a form lease, or in proprietary leases that are worked up by the attorneys for large corporate landlords. To me, in my experience, those are the two places I see them the most. But I will point out that the Bar Association form lease does not include one. And I can't speak for every single lease put out by the Minnesota Multi-Housing Association, but the copies of the MHA form leases I've seen don't go this far to exculpate. So I couldn't estimate. I don't have the data to say how common these are, but I certainly see them a fair amount, particularly with leases that are from general internet resources, or the ones that are like your 40 to 80 page lease from a giant corporate landlord. So what is our practice pointers? Well, if you do have exculpatory clauses in your leases right now, they may be ineffective with regard to negligence. Your current clauses may not cover negligence unless they specifically, clearly call it out. Because if you want to exculpate a client from negligence, it has to do so clearly and unequivocally. This is the language from this case, Justice versus Marvel. You have to exculpate yourself from negligence with either specific language that is either specifically says I exculpate from negligence, or so clearly covers that conduct that somebody can understand it. In general, Homeline does not advise on personal injury issues. At the most, we can explain to somebody what the implications of one of these clauses in their leases are. I can't really get into, I don't have a broader policy opinion on it, but as a practice pointer, it is very much worth pointing out that if you're drafting leases or reviewing leases, this is something to watch out for.
Dan, a couple things. First of all, this was a Supreme Court case, Minnesota Supreme Court case?
Yes.
Okay. And you mentioned precedential versus non-precedential. This is precedential.
Yes.
All Supreme Court cases are, correct? They don't unpublish or non-precedent any of their cases?
As far as I think they probably could if they wanted to, but in general, all Minnesota Supreme Court cases are completely precedential.
So the key here wasn't really the language of the waiver, but Or it was. It wasn't
was.
the fact that the kid didn't sign it themselves because they really couldn't.
You're taking me back to Professor Matheson's contract law class. You generally, parents can bind their minor children to waivers because when it comes to exculpatory clauses and suing, a parent can bind a child to an exculpatory clause. In fact, the facts of the case show that the parents and the playhouse operator did come to a very small private settlement. I don't have the full procedural posture of this case dedicated to memory. They wound up litigating this issue because ultimately the child was not bound to that settlement agreement, which settled the issue. They found that settlement, you can bind your child to an exculpatory clause because ultimately it's like your liability, but you can't bind your child to a settlement agreement. That's a fun contract law hypothetical.
Well, I'm glad you explained what this case was about, because any thinking person would assume it's a comic book dispute.
Yes, I have thought a lot about the fact that Carter Justice is suing Marvel LLC.
Mm-hmm.
As a postscript, 3 years after the plaintiff's injury, our state legislator actually passed a statute which made it impossible for inflatable play area companies from exculpating themselves from negligence. So this defendant couldn't even do that now if they wanted by law. We just have this agreement that was signed 3 years before that. It does seem to me that this case has ultimately settled. There was some other appeals that were dismissed by stipulation. There's been no action in the underlying trial court case since October 13th. So I think this may have settled ultimately privately, but not before setting some precedent that ultimately helps people know when they're signing away their rights to sue somebody for actual tangible harm. So I can see I'm losing people on the technical issues. That's okay. I do have another hyper technical case that I am going to speed through. This was a very, very, very big Minnesota Supreme Court case. Essentially, it said, hey, what can landlords who build their buildings using subsidized municipal bonds charge for rent? Municipal bonds issued under the Minnesota Bond Allocation Act must limit their rents to the language in the law is the area fair market rent. Well, a local landlord who happens to be one of the biggest residential landlords in the country said, hey, I don't want to use the figures that HUD puts out for this exact purpose. I'd rather use another number. And the Minnesota Supreme Court clarified, no. If your property that you're operating was built with municipal bonds issued under a very, very complicated bond allocation act, and just in general, these are generally what we call Section 42 properties, or LIHTC, LIHTC. In Minnesota, we call it HTC, tax credit properties. I think in common parlance, I often hear them referred to as market rate properties, but that's not a technical term, but it usually lets me know what I'm looking at, and I can ask more questions. Essentially, the maximum rent for one of these properties is set at HUD's annual fair market rent figures, not what your local public housing authority puts out for Section 8 rents. I don't anticipate seeing any questions about this. I guess my practice pointer on this is if landlords don't wind up running one of these properties by accident, and generally I think they know what rent to charge. It is possible some of the companies that run these buildings do delegate a lot of authority to their local property managers. So it is possible that somebody could get the rent wrong. So, if you are representing a tenant who lives in a LIHTC Section 42 market rent property, check the HUD figures and make sure they're not being charged too much rent. Again, I'm going to push through this case. This is another pandemic holdover case. essentially a bunch of large landlords got together and sued the state and said, hey, when you issued an eviction moratorium under the Emergency, Procedures Act, I don't know the name of the exact law, but the under this law that gives the state permission to act under emergencies, you commandeered our rental property. And because you commandeered our rental property to fight the pandemic, to fight the emergency, you owe us just compensation. This is a fringe legal theory that is, in my opinion, designed to discourage the state from regulating landlords. We have seen some big landlords try this under different theories of law. You might say, this sounds like a takings case. And that's what the court said. Boy, this sounds like you're trying to take another bite at the apple with a takings case. And why am I bringing this up? Well, if the plaintiffs had somehow won, the state would have owed any landlord who was in any way harmed by the eviction moratorium just compensation. Why? Well, commandeering is really, this law is designed for, like, if the state says, hey, I need your dump truck to help build a temporary dam to prevent flooding. Hey, I need your parking lot to stage emergency vehicles. Hey, I need your gymnasium to run an emergency shelter to house people during a tornado or something. That's what this law is really about. It's not about regulating businesses. There was another case that was decided on the same basic question. That was Buzzell versus Walls, and that was a restaurant. So Duran 610 came at it from the landlord side. The Buzzell came at it from the restaurant side. Essentially, this is part of long-running, and there's even more of it, long-running litigation by landlords against the state to try to punish them for issuing the eviction moratorium. There's no doubt that the eviction moratorium had tough effects for some people. It was also necessary to fight a public health emergency. So there's ultimately, these plaintiffs filed a takings and contract clause case that is going to be heard in 2 days. So if you're interested in more fringe legal theories, tune in then. So we're going to get back into some cases with some more interesting facts and that are more directly applicable to our practices in 2 notable non-precedential opinions. Now you may say, Dan, why are you talking about non-precedential opinions? You told me they're not governing law. Well, they're not, but I think these 2 cases in particular provide very, very useful practice pointers, some on points of law and some kind of more strategic. So Duran versus Stone. You'll notice this is the same corporate landlord that is suing under the last case, the fringe legal theory. This case is an eviction for material breach based on a physical altercation at the building's pool. In this case, this is a very expensive apartment building. I believe the rent was $4,500 a month. The defendants in this case, the landlord is trying to evict them because another tenant they didn't attempt to evict this guy, another tenant hurled homophobic slurs at them at the pool and then actually threw a canned drink at them. There was then a physical altercation where the tenants involved, kind of pushed the guy into the pool, and the landlord tried to evict because the lease prohibits acts of violence. The landlord, the landlord says, "Hey, you push this guy into a pool. That's an act of violence." They didn't try to evict the guy for throwing a Truly's canned seltzer at these tenants' head. That was in the court's decision. It was found by the court, in fact, to be a Truly canned seltzer. So the trial court said, no, you can't evict them. You did not prove a material breach of the lease because I find that the defendants acted in self-defense. And the landlord said, hey, you have to apply criminal self-defense principles, and tried to get the trial court here to use the criminal self-defense standard, which I do not know. And it doesn't matter because the Court of Appeals said, no, it was not an error to apply criminal self-defense principles to conduct under the lease. Specifically, the plaintiff, the landlord in this case, argued that the defendants had an opportunity to retreat. The trial court and the Court of Appeals agreed you just don't have to apply a criminal self-defense standard. There are different burdens of proof in different standards in criminal proceedings than there are in civil proceedings. And they just said, hey, if the trial court didn't have to. Now, this is not binding. I would say it's persuasive. If I was representing a similar client, I would cite this case and say, hey, other courts have found this to be the case. But it's not binding. So what's our practice pointers here? Well, I think that there's a clear reason why this was actually appealed. And that's because the lease between the landlord and the tenants had an attorney's fee provision. And that attorney's fee said, hey, if we, the landlord, have to sue you and we win, we get our attorney's fees. Well, there's a law in Minnesota that says that any attorney's fees provision is automatically reciprocal. It is bilateral, even if the text of the clause doesn't say that. If the landlord can win attorney's fees from the tenant can win attorney's fees from the plaintiff, and the tenants were awarded around $13,000 in attorney's fees in this case. So if you ask me, that's the real reason this case was filed, is because the defendants don't, the landlord does not want to pony up $13,000 in attorney's fees after losing a case.
Dan, I just wanted to sort of not exactly correct something you just said, but I think maybe make the sentence complete. The attorney's fees bilateral provision statute that you're talking about is just for landlord-tenant law.
Yes.
Right. It's not constant throughout Minnesota where all attorney's fees clauses are bilateral. It's just 504B, the chapter where we find landlord-tenant laws, specifically has a bilateral fees provision built into it.
Thank you for that clarification. That is important. I have the citation there. Those are your coordinates. You can look that up. Practice pointers. Be careful with your attorney's fees provisions, and maybe try to evict. Be careful with the evictions you file. So the next case, this is probably the case that I have talked about the most this year, and maybe by discussing it now, my friends and family will finally stop hearing about it. This is Sade versus Old Home Management. A tenant and a landlord agreed that the tenant would vacate the apartment at the end of June. The lease is ending, and this is the language that the court found, at the end of June. Well, on June 25th, the landlord's employees entered the apartment and threw away all of the tenant's belongings. The tenant was in the process of moving out and had left some things behind, and the landlord threw it all away. If you'll notice, June 25th is not exactly the end of June. The landlord tried to argue that it was. I'm going to go back to Professor Matheson, my 1L contract law professor. He taught me that you should only ever make an argument in court that you can make with a straight face. And that would be impossible for me in this case. The 25th of June is not the end of June.
It wasn't a leap year, right?
Yeah, it wasn't our special quatriennial June 25th end of the month to catch up the Gregorian calendar. And so you might say, well, what's the deal here? Well, as it turned out, the tenant had around $46,000 in gold jewelry hidden in a dresser. They also had about $12,000 of other property. The landlord threw away about $58,000 worth of the tenant's property. Well, we have a statute in Minnesota, 504B.271, sometimes called the abandoned property statute, and that's how I'm going to refer to it, that says that if a landlord unlawfully takes possession, or if a landlord is in possession of a tenant's property and they don't give it to the tenant within 24 or 48 hours of a written demand, depending on certain facts, that the tenant can sue for up to 3 times the value of the property. So the court actually didn't triple them up. They only doubled them up. And the reason I think this got appealed is because the court ordered a judgment of $117,000, not including attorney's fees. I will say, I talked about this case with Paul, who chimed in earlier, and I think we're in agreement that one of the main reasons this got all the way here is because the landlord offered the tenant $100 to settle the case. It's kind of egregious here. Not the court's decision, the landlord's conduct. And so the Court of Appeals upheld that award. The problem in this case is that the tenant never actually gave a written demand, never sent a letter that said, hey, give me my property. But she did file a small claims court case. And the Court of Appeals said, oh, look, you get away with this one time. They found that the conciliation court case filing counted as the written demand required to get double damage or to get triple damages under the statute. But the Court of Appeals made it really clear, and this is your practice pointer, send a formal written demand. Mike has impressed this on me, and he will tell anyone who's working for Homeline and all of his clients. Doesn't matter if you know that the property is gone. Doesn't matter if you saw that your landlord throw it into the furnace themselves. Send them a letter. Send it certified. Prove in email that shows that you requested your property back. Also, practice pointer. Don't throw away I know that turnover is hard for landlords and that it's really stressful to turn apartments around. I genuinely mean that. That's probably, in my opinion, one of the harder parts of the job. Don't throw away your tenant's belongings. Comply with the law. The law requires you to keep the property for 28 days. The fact is, the landlord threw away the tenant's belongings before the lease was even over. But even if they had waited till the end of the lease, they still have to keep any property left behind for 28 days after the tenant has moved out or disappeared or whatever. Yes, Tess, I have talked about this endlessly because I actually think this was really good trial work. I go look at the record in this case. Go look at this is a really well-argued case by the plaintiff's attorney. And the judge's opinion in the trial court is a really interestingly written decision because they have to do a lot of math. They have to do a lot of fact finding. They have to take in a lot of different kinds of evidence. And I think it's like a very interesting case that was really well written at the trial court level and at the appellate court level. So
Dan, I mean, sort of analyzing this case requires a bit of an understanding of 504B.271.
Okay.
So what that case or what that statute says is, you mentioned the 28-day rule. The landlord's got to hold on to property for 28 days. And you've also mentioned this written notice. So the tenant gives a written notice to the landlord that says, hey, you got my stuff. I'm within the 28 days. And I'm going to be coming over to pick it up either tomorrow if it's stored on site or a couple days from now if it's stored off site. So was the case filed within the 28-day period?
No, it wasn't. So, but the end of the 28-day period does not exhaust, the tenant's rights. If the landlord still has possession of the property, then the tenant has the right to demand it. After the 28 days, the landlord has the right to dispose of it or to sell it. But they have to give notice to the tenant, and that was not done in this case.
Yeah, I'm not sure I agree with praising all parts of this case, but I'm guessing that the judge really wanted to fine for the tenant because of June 25th.
I agree. I think that that's why this is a non-precedential opinion.
Mm-hmm.
I think that this is a case. The court, I worked on the Court of Appeals for a minute in law school, and one of the things they always beat us over the head with is that they call it an error correcting court. That's part of why they have non-precedential opinions.
It's a makeup call, like in sports.
It's kind of it feels to me like, I can't say a makeup call because I think this is a strike, but it's on the edge.
Mm-hmm.
And
okay.
if you want to read it, it's a borderline call. If you want to read the Court of Appeals opinion, there's a great discussion about the history of conversion claims, which is great for nerds like me.
Which this could have been. It might have made more sense as a conversion claim. Yeah.
So just for people that aren't nerds like me and Mike, conversion is just suing somebody for the unlawful taking of your property for the value of the property.
Right. It's like a civil form of a theft claim.
Exactly, civil theft. The tenant had a valid conversion claim no matter what. She still had a valid conversion claim. The key here is conversion doesn't give you triple damages. The failure here is really the tenant could have gotten about $58,000 in a conversion claim. what the reason why they got about 117,000 is because there's a multiplier involved in this specific statute. And that's why this statute imposes certain specific procedural requirements. And in return, if you say those magic words, you can get triple your damages. The Court of Appeals did not award treble damages. They just affirmed the judgment. The court only awarded double damages in this case. I don't have that reasoning at the top of my head. I think the court basically looked up and said 117,000 damages is enough. So the Court of Appeals is generally not going to disturb a trial court's like specific findings. It's either going to affirm it or it's going to remand it and say, hey, do it right this time. So the Court of Appeals upheld the double damages award. The court does not have to award triple damages. It has the discretion to award triple damages. So it's not a must. 3 times is not a must. So are there any other questions about, if there are any other questions about these cases, I am going to move into, I was going to say, we only have about 12 minutes left. So do we want to just move into the general question and answers rather than go to the cases to watch for?
Yeah, we honestly don't have, if you want to put those up on the screen, you can go ahead for that. We don't have a lot of pre-submitted questions at this point.
We've answered all the questions in the box.
We did have a couple of pre-submitted ones. So I'm just gonna grab those real quick. Why don't you take a break, take some water, put Mike in the hot seat for just a second. But again, if you have, for folks out there, if you've got questions, whether it's about this or general landlord tenant questions, feel free to drop them in the Q&A and we'll do our best to answer them in the time remaining. One other thing I did want to also plug while we are waiting on this is our next month's webinar is going to be on bankruptcy law and how it impacts or intersects with landlord tenant law. So that should be really interesting, I think. So, you know,
I assume we'll apply for CLE credit for that class as well. Yes. Okay.
Yes, that is the plan.
Was that a yes?
I said yes.
Oh, okay.
Which is a very emphatic yes. How about that?
Got it.
It's got more E's and more S's in it. So clearly it's more emphatic. All right, Mike. So we just really had 2 questions. Caleb, who's a service provider, wanted to know how far back property managers can look at for misdemeanors and felonies. I'm assuming that is in applications.
I would assume, yeah. Short answer is, in most places in Minnesota, as far back as they want to look. Minneapolis has its recently enacted tenant screening protections built into place at the outset of the application process, but there are 2 versions of what a landlord can do in Minneapolis. This is city of Minneapolis alone. And so there's a multi-layer answer in Minneapolis itself. Outside of Minneapolis, everywhere else, a landlord can look as far back as they want to for felonies or misdemeanors. Most don't. Most sort of cut it off at a certain number of years, like no felonies that are 10 years or older. But they could. There's no specific law that says that they absolutely cannot do that.
So, thank you.
Mm-hmm.
And then Kathy, who's also a service provider, is just wondering about the legal status and enforcement of renter protections.
I saw that question. I'm not exactly sure how to answer that.
Yeah, I don't know either. That's
maybe
just
COVID, maybe the eviction moratorium.
Well, so if Kathy, if you're here, you can maybe drop a couple more details into the Q&A.
But if it is COVID, that's kind of an easier question. Sure, if you're right, because you might be right, Dan. That might be it. Mm-hmm. So yeah, there's no more COVID protections in place. The only thing that really matters anymore still is the CARES Act. Yep. CARES Act notice requirement. So if a landlord is in a building covered by the CARES Act, which is basically any building that has a subsidy attached to it, that's a loose definition of it. They have to give a 30-day notice before filing an eviction for non-payment of rent. That's a leftover from the first month of the pandemic in this country that was never sunsetted legislatively, so it's still on the books.
We do have a question in the question and answer box
Yep,
about
I am.
jurisdiction.
Yep, I'm grabbing that just a second here. Just, that in the chat, I just dropped some links that help folks can try and figure out if their particular building is covered under the CARES Act, because it's a fairly complicated list of things. All right, so Bree is just wondering quick, if someone is locked out illegally in Hennepin County, leaves and then sues, what court has jurisdiction over that? So
I'll be honest, Bree, I haven't seen a lot of cases with that exact procedural positioning, but I can say this. If you want to sue somebody in conciliation court, small claims court, which is, I'm guessing, where a case like this would go, unless it gets over the $15,000 threshold, you're allowed to sue either in the county where the defendant resides, so that would be the landlord in a lockout case, or the county in which the property is located. Sort of the tenant's choice, which one they want to sue in that situation. There's a special conciliation court rule that covers the fact that you can sue in the county where the property existed for a tenant issue. So, and I think conciliation court is still being done by Zoom. So I can tell you during the pandemic, we have had people that have sued landlords, mostly for security deposits, in conciliation court from literally all over the world, where they've appeared from, another country or certainly other parts of the United States. So Zoom has given people a chance to do that. Oh, and Bree followed up with saying, even this is a misdemeanor to illegally lock somebody out. Yeah, so the misdemeanor part, it's not like the tenant is going to be able to file a misdemeanor, or the police would have to decide whether they're going to try to hold somebody criminally liable, or the county attorney. You don't really sue for a misdemeanor under a lockout. You sue for the damages, which is found in a separate statute in landlord tenant law, where it talks about what you can sue for as a result of an ouster or a utility shutoff.
all right, thank you for that. And then Judith.
This one's yours, by the way, Dan.
Yeah. What is the status of the Section 42 property FMR case? Dan, you are on mute. 3 years into the pandemic, and
no, he was just thinking. He wasn't on mute. He's just thinking.
This is a class action case against this landlord and all they have a lot of different legal entities. So this is a class action complaint. The class action complaint was filed in 2022. We are finally now basically the tenant has been given the go-ahead to actually sue, and the determination that the rent is wrong. Talk about month of the pandemic. This case was filed on March 18th, 2020, which is, I believe, the last normal day that ever happened. I believe that's that Thursday. Oh no, it's the Wednesday. So it's like Wednesday or Thursday right before the world shut down. So that's when this case was filed. It is now moving ahead to trial. If you look up the documents in the case, you'll be able to find the case number. Actually, I can put the case number there. You are welcome to follow this case, slog its way through trial. Will probably be years before we come to any sort of conclusion on it. After the Supreme Court's decision, they've moved ahead. I want to see the next. Let me see if they actually have a trial scheduled. Yep, there is there's not currently a trial scheduled, but you're gonna see it kick up soon. Again, it's a class action complaint, so this will probably be fought over for years and then settled. But
Dan, what were you looking at there? Was that Mincis that you were looking at to see the?
I was looking at
there's a case.
MCRO, MCRO.
Okay.
Thank you for.
Yeah, Rachel, do you mind putting that in the link? For those of you that have never looked this sort of thing up, it's easy to look up cases in Minnesota now. They've become really publicly available. The first one Rachel just put there, the Minnesota Court Information System, is where you can see the basics of the case, the parties involved. You don't need a special lawyer, password, or pay any fee to look this sort of thing up. Although I will tell you this, it will ask you to prove that you're not a robot, and on your first attempt, you will fail. It'll ask you to retype some letters on the screen, and you'll think, oh, I think I got it right, and you didn't get it right. There's nobody that can. But then it gives you a second version that's much easier to get right, and you can prove your non-robotness the second time through, almost every time. But anyhow, you can see whether a case has been filed, who are the parties, and then on Micro, the other one in the chat, you can actually look at documents that have been filed officially with the court, or any orders from the court as well. Very useful. If you've never looked up court cases, and you wondered, you just thought there was some barrier or hurdle that would stop you from being able to do it, in Minnesota, it's quite easy to look up a great deal about court cases right now, the minute they're filed.
And yeah, it is currently free to do so, which is delightful and should remain that way, I believe. So
yeah, we're in a pilot project stage with Micro. Minsus has always been free, but the Micro is free right now, and I believe there's legislation being heard this year to, I think, make that permanent as well.
That's my understanding as well. So
used to have to do silly things like pay $5 for, 1-page copy or of anything. Yeah,
it could get pricey, especially with 50-page complaints.
Yep.
So all right, so we are essentially at time. So if there's any last second questions, feel free to drop them. But I want to say thank you to everybody who joined us today. It's been a really interesting session and really informative. So thank you so much, Dan, for all of your time and research. And hopefully this has gotten everything out of your system for the sake of your friends and family. We will be hosting another webinar on February 15th. So just under a month, regarding bankruptcy, and more information on registering for that will be forthcoming. So
same time of day, right? 1:30.
Yep. Wednesday, 1:30 to 3 p.m. And we'll be applying for CLE credits for that as well. So yeah, thanks everyone. And the recording of this should be posted to our website within a few days, if you want to come back and look through it. So thank you all, and have a wonderful rest of your day. Bye.